you okay with an oral motion for continuance?
Yes, Your
Is there going to be any objection?
Honor. No.
All right, so we'll go on the record. Court is calling 2023 CR 10038, 2023 CR 10039, and 2023 CR 9782, State of Texas versus Roberto Benito Andrade. Could I have parties announced for the record for the state?
Audrey Hilma for the state.
Defense?
Megan Enriquez, present for John Keats for Roberto Andrade.
And are you Mr. Andrade?
Robert Andrade. Yeah.
Yes. Is that you?
Robert. Yeah.
Yes. All right. State, you're scheduled for a jury trial today?
Yes, Judge. We were able to reach our complainant. However, she made us know that there was a death in her family. She's unavailable this week for the trial. So we would ask that the court grant a motion for continuance at this time.
All right. Any objection to the state offering an oral motion for continuance?
No, Your Honor, we would ask that it be a short reset, if possible. We have been conferring all morning. They have made a generous offer to my client. He's rejecting it this time and is requesting a jury trial.
All right. So the state's oral motion for continuance will be granted without objection. And then do you have any update as far as your complainant's availability?
I feel like she just said this week wasn't. So sometime in the future when we've got our trial set, I think should be appropriate.
All right. All right. All right. We'll go off the record. Ms. Ferguson, if you can give them the earliest trial setting.
Thank you, Judge.
You're welcome. All right. June 4th. It will be June 4th.
Thank you, Judge.
You're welcome.
Yes, that's it.
Yes, sure.
Regarding the bonds, the state cannot agree to a bond reduction. Would you entertain argument for a bond reduction, or do we need a bond motion?
Well, if you all, since y'all don't have an agreement, then Judge Nahara is really not going. Well, I mean, Judge Nahara would still hear it, but if you all want to wait around to see, because I have a couple of matters that I need to take up.
Okay.
And then I will hear it.
Okay, I'm gonna
Sure.
run down to the 399 on another setting, and then I'll be back up.
All right, thank you.
Yes.
Hi, so what's happening with your jury trial? Ah. Can you see if he's still available, if he can come up here? Yes. All right, thank you. All right, thank you.
He's fine. Yes.
Yes, I do. Okay.
No, not that. Yeah. No, I know.
Right, yeah.
All right, who's here on Rolando Gomez? Are you all ready? On that one, they want a bond motion. All right, are you all ready to proceed with sentencing?
We are, Your Honor.
Okay. Court is calling 2024 CR 1562, State of Texas versus Rolando Gomez. Can I have parties announced for the record for the state?
Hey, looking for the state.
Roger
Defense.
Pettis for Mr. Gomez, Your Honor.
And are you Mr. Gomez?
Yes, Your Honor.
All right, we're here today for sentencing. You entered a plea of no contest and a plea of true to paragraphs 1 and true of the enhancement. The court found there was sufficient evidence to find you guilty. And we are now here for sentencing according to the plea bargain agreement. Punishments be assessed at 4 years in the prison, and the state is silent on your application. And I believe on this case, there was supposed to be a TAP evaluation and a DDRF evaluation. Are both parties in receipt of the DDRF evaluation and the TAP evaluation?
Yes, ma'am. Yes, Your Honor.
All right, any objections?
No objections, Your Honor.
All right, the state is silent. Anything you wish to say on behalf of your client?
Judge, Mr. Gomez has understood that he has made a little bit of an error in this particular situation. He's gone through some issues, both physical as well as recently mental. He went to SAFE many, many years ago. He has access to family members that he can stay with. We understand that there's an appointment for a DDRF or a MIC appointment in June 27th. We're wondering if the court would be would grant him the honor of probation, and he would immediately make that June 27th deadline. And he understands that if they rule that he needs some assistance, that it would be an inpatient program, and he's motivated for that. He's motivated to try to get these things behind him.
All right, anything you wish to say, Mr. Gomez?
Yes, Your Honor.
Yes, what would you want to raise your right hand?
No,
You don't want to say anything?
I'm good. Thank you.
Okay. All right, so this is where we are. Where we are is you continue to pick up cases, right? And I know there are some underlying issues as it relates to those cases. So you're going to have a choice. People always say that probation in this court is very difficult, but I don't do cookie cutter conditions of probation. Hopefully the conditions I'm setting for you are designed for you to change your ways and for us not to see you anymore. So if you would like, I can sentence you to 3 years in the prison, or I can place you on probation, but what's going to end up happening is you're going to remain in custody. You're going to have a review with the DDRF. And if DDRF doesn't accept you, you're going to safety. So those are your choices.
Program.
Well, I mean, your attorney's saying program for you, but here's the thing. You know yourself better than I know you, better than your attorney knows you. You know whether or not you can successfully complete probation. What I'm telling you is, people say that probation in this court is difficult, but the conditions that I give you hopefully are conditions that can help you rehabilitate yourself and become a citizen
Yes, sir.
and an upstanding citizen.
Yes, sir.
You understand? So the question becomes whether or not you want to do prison or whether or not you want to have treatment. Either way, you're going to be in custody.
Can you give us just a minute?
Sure. And Mr. DeLeon. Norma, Michael's available for that. And we're off the record while they discuss. Mahia, there's always long discussions on whether you want treatment, prison time. Have y'all finished your discussion?
We have, Your Honor.
All right, we're going to go back on the record.
Program.
Okay.
Yes, sir.
All right, so this is what the court will do. The court is going to sentence you to 4 years in the prison, suspended and probated for 6 years. There is going to be regular reporting by Zoom or in person. The UA hotline upon release. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. Probation, do you think felony drug court would accept him? All right, so first, a referral to felony drug court. If not accepted, then he can remain in custody for DDRF. And then if not accepted to DDRF, then it'll be SafeP. And if he's not accepted to felony drug court when he's released from custody, then it's going to be 90 sober meetings in 90 days. Field visits 1 time per month for 4 months. And the CATS theft course 1 and 2. Probation, is there anything else he needs? All right. Yes. Defendant is to remain in custody for all evaluations. Do you have any children?
Yes, ma'am.
What are their
They're all-
ages?
They already graduated.
All right. And there's going to be 200 hours of community service restitution. And those hours will be not waived. How far did you go in school?
Tonight.
All right. So what type of employment have you had in the past?
I get benefits every month.
Benefits for what?
Social Security,
I mean, why? Why is Social Security giving you funds?
mental.
Okay. All right. 200 hours, but he says he's receiving Social Security. So proof of employment within 30 days of release or proof of SSI within 30 days of release. And there should be no unsupervised contact with minors. And we're also going to have to do, if DDRF doesn't pan out, then it's going to have to be MIC or either referral for Center for Healthcare Services.
Not getting out to it. Until they do an evaluation, they either send you to one facility or another. You're gonna be on probation for 6 years. But you're either gonna go-
All right, is there anything else? Is there anything else that you need from the court to be successful?
That's it, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
We can go off the record. In this court, probation, to be successful, communication is key. If there's an issue, let your officer know. If you feel as though they're not addressing it, you can always come to court. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you.
Did we give, June 4th? So Norma, the people we have left on the docket are Christopher Davis, Anita Herrera, and Yvonne Pettis. Okay. No, Bob Barron is looking at that. Yes, on Juan Vasquez. He's here.
Oh, it is.
Yes. Hello.
Hey, can I just want to real quick?
Sure.
I had a brief discussion with Miss Ephraim Lorraine about Nicholson. And I
Oh, oh, there's Michael DeLeon.
I need to talk about that.
Deputy Laura, who's the female on the back row? Ah, his client. Okay. So now we just have about 3 or 4 more cases on the docket. And they're doing a plea. So then his case is up. Yes, that one, Yvonne Perez may be a trial.
Oh, no, I. No.
Yeah.
As long as it's. You know. I shall.
Oh, no, it's you. I mean, we can. But she-
Yes, I mean.
Yeah. Megan, on Roberto Andrade, which case are you requesting a bond? Okay, yes, I'll need all three.
Oh, I'm sorry.
Hello.
Hi, Judge.
So we're just, okay, we have a question. I don't
Sneaking
know
up on you.
if Ally wants to be up here. Bob and I were talking about the victim impact free or the victim impact fee.
So we were talking with the judge earlier about, you know, the side of things. And it would be plea today. Okay.
Oh, she's ready.
Um,
And I'll explain to you about victim impact in just a moment. All right, Anita Herrera. All right, on this case, Mr. DeLeon, I know you're newly appointed. Is there any type of mental health issues?
Apparently there was an evaluation done at some point.
Mhm.
Everything's gonna be fine.
Okay. Yeah. All right, so State, did you tender an offer or no?
Yes, Your Honor, I wrote an offer in the file.
All right, and the competency evaluation, it shows a waiting for June 29th. So has it been entered or heard by the magistrate's court?
I'm unaware, Judge, but after talking to Ms. Herrera, I feel like, feels to me like she's competent. We had a very good conversation about the case and possible defenses, so I'm comfortable with proceeding. It's just a matter of going through the discovery. Apparently there's some videos, stored videos. I need to do that out of due diligence, and then we can talk to the state again.
All right. So in this case, if somebody can just check with the magistrate's court to make sure that competency has already been heard, because my understanding legally, once it's been filed, then if you don't want to no longer have the competency, that's something that has to be put on the record with the magistrate's court. So what date do you want to come back, Mr. DeLeon?
Seeing what dates I have in this court already, Judge, to make it ideal. Yeah. That's a bad idea. How about anytime in June?
All right. Do you want to do it at the beginning of the June or the end of
Let's do
June?
Monday, June 3rd.
All right.
I have
Norma,
one
can you
other
call
case
this
in
back?
here.
All right. So Ms. Herrera, we're going to come back on Monday, June 3rd, okay? And the reason why your attorneys will switch is because there's certain requirements when attorneys are on the wheel, what cases they're allowed to handle. So this is attorney who's allowed to handle your level of felony, all right?
Okay, and I went to court with a competency.
Mhm.
They told me I was competent.
Ah, okay, then that solves that problem. All right, is there anything else you need?
No, ma'am.
All right, thank you.
Thank you.
Be in touch with you.
Yes,
Okay.
thank you.
Oh, no, she should go ahead and do it. That's on the defense attorney. Suzanne? On your client, do you have the federal case number?
I'm doing it right now. They
Okay.
have not been calling me back.
Okay, all right, thank you. Yes. Well, just give me, Suzanne, they're gonna have to put it in the system by 3 o'clock.
Is Jason coming back?
Yes,
Okay. Because he might be able to help me.
all right. Is there anyone in the courtroom who's licensed in federal court? All right, can you look up a cause number for Suzanne Kramer? Look at me, I'm solving problems.
I'm not a subscriber to that.
Yeah.
Computer system thing.
Yeah.
Seriously?
So what do you want to do with Mr. Vasquez, or what do you want us to do with Mr. Vasquez?
Oh, so Mr. Vasquez has the violation reports. So I didn't know if you all were gonna work something out or not. Because it's a theft under $2,500 enhanced.
Okay, yeah, and I don't think they have that file here, the original, because it's still unindicted. Right?
All right,
You want to look at?
So there's, for my chain, there's one drug case that's unindicted and even more than cases unindicted.
okay.
Correct. So do you want? I guess you can't do anything until you have the drugs.
All right, so counsel, I'm gonna issue a judge's warrant on these cases because it appears that while he was on a PR bond that someone gave him, that he picked up 2 new cases.
I think you have them here in the box already.
Yeah. Okay,
And he's already showing us those. Right, he still shows bond on the original.
okay. All right, Deputy Laura, Juan Vasquez can go back. And what is happening on Yvonne Pettis?
Good. We've been in communication on a possible plea, I believe. You wanna, I guess.
I'm waiting, kind of.
It
Okay.
needs higher approval that hasn't.
All right, all right, we'll wait for that. All right, while they're doing that, let me know when you're all ready for Andrade. All right. I'm so sorry, I called you and then now they have this, but yours should be short. Wait a minute, yours is short, correct?
Yes, Your Honor.
All right, so I'm going to take up the bond matter. And then after the bond matter, we're going to take up Christopher Davis, and that'll give time for Ms. Kramer to get the federal cause number to them in the back.
That's helpful, Judge.
Okay. Okay. All righty. All right, so two of these cases are criminal trial division and one is family violence. Are you handling the bond issue for both?
I'll handle both, yes, sir.
Okay. All right, the court is calling 2023 CR 9782, 2023 CR 10038, and 2023 CR 10039, State of Texas versus Roberto Andrade. Can I have parties announced for the record for the state?
Marjorie Hilma for the state.
Defense?
Megan Enriquez, present for John Coots for Robert Andrade.
And are you Mr. Andrade?
Yes, sir.
And everyone, just 2 moments.
I had one. Already beautiful. For them.
When you feel it coming, you gotta nip it in the bud. All right, we're here for an oral motion from the defense for a bond reduction. Any objection to it being an oral motion, state?
No objection from the state.
All right, defense, we'll start with cause number ending in 9782. What are you requesting? The bond is currently set at $20,000.
Yes, Your Honor. In the cause number ending in 9782, we're requesting that the bond be reduced to $10,000. In the cause number ending in 10038, it is currently set at 10,000. We're asking that it be reduced to $5,000. In the cause number ending in 10039, it is also set at $10,000, and we're requesting that it be reduced to $5,000. My client has been in custody for 281 days. He's been in continuous custody since these bonds were set at these current amounts back on August 1st of 2023. He's been requesting a jury trial. Just earlier, we agreed to a short continuance based on a state's witnesses unavailability. So for those reasons, we're respectfully asking the court to cut the bond amounts in half from the current amounts. His family has been making attempts to raise money and have just fallen short from the current amounts.
Okay. All right, state.
Your Honor, at this time, we're opposed to reduction in bond on any of the cases. He was actually, all three of these cases are closely related in time. They're less than about a week apart. I believe the cause number ending in 9782 occurred July 21st, and the other two cases occurred July 31st. As well as this repeated violation of protective order or bond conditions in the Family Violence Division. The other two cases he has pending are one is a second degree drug case. The other is an evading, which occurred at the same time while he was in the process of committing the second degree drug case. Based on the repeated violations, there was violent tendencies and aggression exhibited in that case. And so we believe
When
that
you
the
say
bonds-
violent tendency and aggression, which case are you speaking
in
of?
repeated violation, the one cause number ending in 9782.
Okay.
There were threats on the victim's life. So at this time, we believe that the bonds are appropriate. They've been appropriately evaluated, and there's been no change, which indicates that they should be reduced in any way.
All right, and since it's your motion, I'll give you final argument.
Yes, Your Honor, to address the concerns that the state has regarding the family violence case, the current bond conditions with the current amount include a GPS monitor with a full house arrest condition. That we're not asking that be changed at this time. He has a place to go live that is with his elderly mother who's in poor health. So he would be at full house arrest with his mother. He does intend to try to get a job or to get his job back that he had before he went into custody. And if he is able to do that, I told him at that time, we can address the court about possibly getting that changed to partial house arrest if he's able to provide proof of his employment and where he needs to be. But in the meantime, to address the state's family violence concerns, there is a GPS monitor condition with full house arrest.
All right, and I see that there was a previous bond hearing. I guess,
That might have been with a previous attorney. Ruben Flores represented him up until, I believe, January.
yes, because that bond hearing was in 2023. All right, and then does anyone have any information for me on criminal history?
Judge, he does have a criminal history that goes back a little bit. It looks like a fair amount of it.
I mean, how is he indicted? Is he indicted as a habitual? Is he indicted as a repeater?
He is. All of the cases include a habitual.
Okay. All right, is there anything else?
Nothing further.
All right, with regards to the motion for a bond increase in each case that will be denied.
The bond decrease.
I'm sorry, bond decrease, yeah. Bond decrease in each motion will be denied.
Thank you for
All
your
right,
time.
is
Judge.
there, you're welcome. Is there anything else?
No, nothing further.
All right, and so Mr. Andrade, on the date that you're coming back, we'll make sure that you are up for trial, okay? All right, thank you.
Thank you, Judge.
Thank
Thanks for
you.
hearing it without motion.
Oh.
I think he had filed maybe a pro se motion in addition to the hearing where they had previously been denied.
Yes, because because I have it in the notes that his previous attorney filed one. And I think we heard it at that time too.
Okay.
All right, thank you.
Oh, Judge, they're still working on Vasquez.
You want me to? I'll wait for Dana to do that.
Oh, okay. Can you stay Vasquez then? And then state as soon as family violence comes back, we'll take up Mr. Davis. And Ms. Kramer, were you able to get a cause number for the federal? Okay, awesome.
Never even occurred to me to ask somebody to look it up on patient.
I mean, if I were still on their list, I could pick that up. Did somebody drop something by the gate? Is that a napkin or is that something else?
It looks like
Looks
a
like
napkin.
paper towels, Judge.
Ah, okay. Just wondering if somebody dropped a document. Mhm. Oh, I didn't. I did not. Sure, no problem.
You have the file?
Sure, let me just write in.
Okay. Just.
Hello.
I got an update. I guess the state is meeting with Joe at 3 to go over that offer.
Okay,
Um,
so nobody can pick up the phone and call Joe?
you know,
I wish I had a cell. I don't think.
I don't know. But Judge, I do need to, I've got childcare issues.
Okay,
Um,
all right, so,
I will, I can, obviously, well, I guess I'll stop talking. I'll let the court know.
so this is what we're gonna do. We're gonna come back here tomorrow at 9 AM. 9 AM.
Okay.
All right, she will be back at 9 AM.
Address?
Yes,
Okay,
all right, 9 AM.
all right, thank you, Judge.
You're welcome.
Yeah.
Could I see the file on Yvonne Perez? I was gonna have my drink. Oh, these are done, sorry.
Good seeing you.
All right, and Deputy Laura, make sure she's dressed for trial. So then we only have two, these two defendants, correct? All right. So in this case. What is? They have all of the discovery. So it is the same. Acknowledgement of the stolen books. So the defense attorney signed the prosecutor notating that everything that's listed.
Yeah.
They received. Now that everything is sort of like computerized, but back in the day, you would have a sheet and you would think like everything's like all of this. Shit right there. You even though it was computerized, when I was in office, I still put mine, because I didn't want there to be any mistakes that somebody puts together. So I always ask them that first to make sure that they have everything, so that other people can come back and say, well, I don't have that. And say the wrong number. And this is the indictment. So this case. This is what is it? The law percent. It's everything. This could probably, it could be the wrong charge, it could be the wrong case, or all of that. What matters is what's. And then. What's that? Correct. But yes. There are some cases of hybrid gases and they have one brain that's so they're like if they were just like us in the street. None of them would fit in this. So they have like a pre-bargaining section to make sure that they say that then you go over it. So some judges they don't go over the judges, so this was start with and regulars. Yeah, so giving up your right to trial, yeah, and the next first, but I like for them to go over everything. I want to make sure that they are agreeing to what they're agreeing to and they go with it. And then you process actually people come back and say, I was never told I had a right to have a class. It's always that. And this is way. You have a right to pick back over. So what that means is just cross-examine or anybody who is saying, he's the person who did that to us. Well, when you set it up to us, their testimony is incorrect. So technically, you're not getting a chance to cross-examine, which is fine. And then of course, follow the pre-bargain agreement. You can give up your right to say you can't come back and say. I mean, you can say that, but the fourth quarter says this is a pre-bargain. You know, now of course there are some exceptions to that. There's some evidence. I thought they on that. So we're going to take this up. Are you all ready on Christopher Davis?
Yes, Judge.
Yes, Judge.
Okay. All right, court is calling 2022 CR 7283 State of Texas versus Christopher Brent Davis. Could I have parties announced for the record for the state?
Allie Jackson.
Defense.
Robert Barron for Mr. Davis.
Suzanne Kramer for Mr. Davis.
And are you Mr. Davis?
Yes, Your Honor.
Counsels, have you received all of the discovery in this case and did you review that discovery with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Davis, did you review the document entitled True Bill of Indictment with your attorneys? Did you understand it?
Yes, Your Honor.
Counsels, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
No, Your Honor, we are proceeding on the lesser included offense of aggravated sexual assault of a child that was contained within count 1.
Any objection? All right, Mr. Davis, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorneys? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
All right, did you understand the state is proceeding on the lesser included offense of aggravated sexual assault of a child? That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
And they would assist in his defense, and we believe he's competent to enter his plea.
Right. Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he was sane at the time of the offense? Mr. Davis, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly involuntarily waived his right to jury trial. Off the record for a moment. Could you mute us, please? Could I have attorneys approach? All right, we are back on the record. According to the plea bargain page, did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
Okay, according to the plea, the state is proceeding on the lesser included offense. Punishment is to be open to the court. What that means is that the court can sentence you anywhere from 5 to 99 years or life in prison. Do you understand?
Yes, Your Honor.
And is it your intention for the plea agreement to be that you plea open to the court?
Yes, Your Honor.
Okay. And then there's chapter 62 compliance, and there's no contact with the complainant. And there's a checked box for no application for community supervision or deferred adjudication. You understand you're not eligible, correct?
Yes, Your Honor.
All right, so you understand that the court will either sentence you from 5 years all the way up to 99 years or life.
Yes, Your Honor.
And that is your understanding of the plea bargain agreement?
Yes, Your Honor.
Defense,
Yes, Judge.
state.
Yes, Judge.
All right, and also I can sentence you up to $10,000 fine. Did you understand that as
Yes,
well?
Your Honor.
All right. Did you review the waiver of appeal paragraph with your attorneys? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsels, have there been any such motions? All right. Then to the lesser included offense, how do you plead?
There were pretrial motions regarding discovery things that you did sign after the state not conferred on them. I think evidentiary motions.
All right. Then to the lesser included offense of aggravated sexual assault of a child, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers State's Exhibit 1 with all attachments. We would also call a witness, Your Honor.
All right. Any objection to the stipulations? All right. I'll allow you to call your witness once I review the stipulations. All right. Mr. Davis, did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Well, strike that. There will be some testimony today. You understand?
Yes, Your Honor.
All right. The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and stipulations. The court will review that part of the evidence that the state is admitting, and then the court will hear any other additional evidence that it relates to the stipulations. All right, so if everyone will just give me a moment. All right, after reviewing states, oh, I'm sorry. You have witnesses to call?
Yes, Judge.
All right. Could you stop video, please? And mute. Right, so in regards to States Exhibits 1 and attachments, I know there are DVDs that are attached. I'm assuming that both parties would like for these DVDs, even though it's a part of the STIPs, to be under seal.
Yes, Judge.
Right, so no objections to the two DVDs, which have written on it NH 0506 and NH 0506, that are videos and phone, for that being sealed.
Yes, Judge.
All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. And if all the parties will remain in court just briefly, I'll see if we can get a PSI done expedited.
Thank you, Judge.
All right, so if you all will just have a seat and I'll give you all the date.
And Zach is gonna step in for me, Judge. I'm gonna go upstairs and talk to the boss.
All right, thank you.
Juan Vasquez?
Correct.
Okay. And is he pointing to one case? Okay. So did I turn, give y'all back those VR reports? All right, because they'll be mute now since they're.
Yeah, they might have any. Yeah, don't totally forget this is a weird one. Yes, ma'am. Who else did she get on?
All right, who are the parties on Juan Manuel Vasquez? If they could approach, please. Court is calling 2024 CR 5606W, State of Texas versus Juan Manuel Vasquez Jr. Could I have parties announced for the record for the state? Defense?
Robert Barons on behalf of Mr. Green for Mr. Vasquez.
Are you Mr. Vasquez?
This one.
All right, do you have any objection to Mr. Barron standing in for Ms. Green?
No, ma'am.
All right, counsel, have you received all the discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Vasquez, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure?
This one.
And did you sign it?
This one.
All right, is he going to be entering a plea of no contest or?
It is going to be no contest, Judge. I'm sorry, I forgot to circle that.
No problem.
And I guess I forgot to put it in the waiver of indictment.
Yes. All right, did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
This one.
Did you understand your attorney also has two rights from the presentation of the information and 10 days to prepare for trial?
This one.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
This one.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
This one.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the information with your attorney? Did you understand it?
This one.
And counsel, are you waiving the reading of the information?
Yeah.
State, are you proceeding on the information as presented?
Yes, Judge.
All right, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
This one.
Did you understand you're charged with theft under $2,500 enhanced? That's a state jail felony.
This one.
Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
This one.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
This one.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call and the right to remain silent?
This one.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has a rational and factual understanding of the nature of the proceeding and the charges against him, and I believe he's confident that.
All right, and do you believe he was sane at the time of the offense? Mr. Vasquez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishments to be assessed at 15 months in the state jail facility. There are no applications. The state is taking in consideration the following NIMAC numbers: 760-921, 760-923. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, it is, Your Honor.
Did you review the document did you review the paragraph entitled trial courts? I'm sorry. Did you review the paragraph entitled waiver of appeal
Yes, ma'am.
with your attorney?
Yes, ma'am.
Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
There have not.
Then to the offenses charged in the information, how do you plead? Guilty, not guilty, or no contest? State any evidence.
State also did one and all that.
No objections.
Did you review the document entitled Waiver and Consent of Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Can we go off the record for a moment? Can you mute us, please, and stop video? And the court is reviewing State's Exhibits 1 and attachments. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing? Anything you wish to say on behalf of your client? All right, then the court will follow your agreement, sentence you to 15 months in the state jail facility, give you credit for any time served, taking consideration night mag number 760-921, 760-923. If you would like, I could request that you be considered for the therapeutic community. It doesn't increase the time that you're in custody, but it could possibly help if you have any drug or mental health issues. Would you like that?
Sure.
All right.
Could you find him eligible to participate in programs?
What ends up happening with regards to that is everybody who's sent to the state jail facility, that a report automatically comes to me. And if you are actively participating, I will know about it, and usually I will give credit for that. But if you're just sitting there passing time, normally I won't give credit unless there's a reason that you're just sitting there passing time. You understand?
Yes, ma'am.
Thank you, Judge.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to the attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. State jail felonies are enhanceable depending on what any new charges you have. And sometimes state jail felonies, when they're enhanced, your range of punishment is 2 to 20. The other thing with you is if you continue to commit thefts, sometimes people end up getting shot when they're stealing from somebody. You understand?
Yes, ma'am.
All right, good luck to you, okay? All right, we'll be back tomorrow at 9 a.m. for Miss Pettit.